I think.
What did you say?
It's been in jail for 34 days.
34 days. Okay. And what's the bond at?
50,000.
All right. So what are the facts of the case?
Your Honor, this individual picked up this case and 1, 2, 3, 4 other felony cases.
What are the other felonies? This is a possession controlled substance 1 to 4 grams.
Yes, Your Honor, and along with this case, on the same date, there's a 2023 0D0 0439, which is a possession. I'm sorry, Judge.
You said it was there's another indictment also?
Judge, there are 5 total.
5 total indictments? Is this the $50,000 bond on just the one case, or is that the total on all 5 cases?
That's just on this case, Your Honor. The other cases already had bonds, and they have been reduced to a different amount, but also with a PR component. But this one is 50,000 still.
So we got 2022 0D0. What's the one we're dealing with is 1264, but what are the other ones?
The others are 2023.
Wait a minute, 2020, they're all 2023s? 2023,
Yes, the rest are 2023, Judge.
okay.
00439.
Okay. What's that
Then-
charge?
That one is accident involving injury, possession of a controlled substance, penalty group 2, between 4 and less than 400 grams.
Okay. Then the next one is,
And then
20
there's, right, 2023 0D0 0291,
and that charge,
theft of property over 30,000, but less than 150,000.
what values again?
Over 30,000, less than 150,000.
Okay. And then,
And then there's 2023 0D0 0288.
okay. And that's,
And that's 2 counts of possession of a controlled substance, penalty group 1/1B. Over 4 grams, but less than 200 grams. And then it also includes a possession of marijuana, less than 5 pounds, but over 4 ounces.
okay.
And then the last one, Judge, 2023 0D0 0289.
Okay.
And that's 2 counts of credit card or debit card abuse.
Right. So what are the facts on this newest case?
Okay, which one do you want first, Judge? Actually, three of them are related.
What,
This,
are they different, are there different dates of offenses or?
No, Judge, actually on three of them, on the 1264, 439, and the 291. They're the same, well, yeah, they're the same date, technically. They involve a car
Wait a minute,
accident.
the what numbers again?
The 2022 case,
Okay,
1264, and then the 439,
okay,
the accident involving injury, and the possession, and then the theft of property, 291.
those are all on what day?
That they all stem from an accident on January 2nd of last year of 2022.
Okay. And somehow he's made the bonds on all of those. Then what are the other dates of offenses on these other charges?
They're close. Well, actually, they're not close. I'm sorry. There's the newest one is the 288, and that one allegedly occurred on January 6th of this year, 2023. That's the possession and the possession of marijuana, possession of a controlled substance and possession of marijuana.
Okay,
And then the credit card or debit card abuse is the date of offense is January 1st of 2023.
okay. All right, well, go ahead then. Give me the facts on. I don't know, it doesn't matter.
Yeah,
Pick,
well,
pick a case.
the old one, Judge, the 2022 cases, those all stem, it's there was a vehicle accident on Dyer and Rushing. When police arrived to the scene, the occupants of the other vehicle said that the driver of a 2015 Jeep Wrangler had fled the scene with a backpack, with two backpacks.
He'd hit them in their vehicle and then fled.
Yes, he left the vehicle, the Jeep Wrangler there, and he fled. And so the accident involving injury is because the victims were transported to a local hospital, but they were non-life-threatening injuries. He was also charged with evading arrest. He evades on foot. He's carrying two backpacks. He's detained at 5112 by police at 5112 Brannan. He's arrested and then searched, and I guess in the backpacks there's 10 grams of THC. Well, I don't know if you want the aggregate weight or if you want the lab reports, Judge.
Yeah, lab reports would be better.
Yeah, the labs came back at 0.8 grams of THC, 2.65 grams of meth.
2 point what? 65?
Yes, 2.65.
Okay. All right.
And 71.88 grams of marijuana. Actually, I'm sorry, Judge, that was what was tested. It's 81.65 total. There were several baggies of marijuana.
Yeah.
So that encompasses the 2022 case and this the 439 case. And then the theft is because the Jeep Wrangler that the defendant was allegedly driving, when they ran the VIN, the vehicle was reported stolen from Las Vegas. And so it was a stolen vehicle valued at $40,000. And that's the 291 case.
Okay. What kind of criminal history does he have?
Well, history, Judge, aside from these pending cases, there was a 2007 BO burglary vehicle, 30 days. A 2010 theft from person and assault of a public servant, 5 years deferred.
When was that?
2010,
And he got, what was that charge again?
it says theft of person, theft from person,
And he got
and
how much?
assault public servant. 5 years deferred.
Did it get revoked or did he serve it out?
It looks like, no, he completed it, Judge. It looks like,
Okay.
and then a 2013 theft of property, $50 to $500, 1 day in jail.
All right. Anything else more you want to add in there?
Well, there's the credit card abuse from this year and then the possession case from this year. The more important one, Judge, is the possession. That ended up being, I guess there was a call at Walmart regarding a theft. He had warrants. When they did an inventory of his vehicle, they found 4 pounds of marijuana, 4 grams of cocaine, and 43 grams of meth. We are still pending the labs on that case.
All right. So now, what do you have to say there for your client's behalf? What, if he gets out, what kind of bond is he wanting or seeking?
Well, right now, he has bonds and he has not made them yet. The bonds were reduced. I think they were probably at a total of about $25,000 and roughly with PR components. I know that the one that the government's most, or the state's most concerned about, actually might be a case that I think they have problems with, because I know the government, they're saying it was an inventory search. However, he was already in custody in the county jail when they decided to go back to the vehicle that was in the Walmart parking lot and search it, and saying it was an inventory search. We'll have all the facts, but right now I don't have all the details of it. If it is as my client says, I mean, somebody else could have gotten in that vehicle while he was, from the time that he was already over here in custody. And it may not be a search incident to arrest or an inventory search. However, I think if you look at the facts of all of these cases, it appears that there is a substance abuse problem, obviously, which is why the bonds have been reduced to have PR components. My client was in Las Vegas for a while. I mean, he lived in Las Vegas and in El Paso, in both cities, but he was coming back to El Paso to answer to what other charges he had here and to take care of the legal stuff that he had left. And so that's why he was back here in El Paso. If released, his mother and sister are now going to be in El Paso. His mom, Sandra Carmona, his sister, Carissa Carmona. He would be living at 4941 Meade Court, El Paso, Texas, 79904. He has a cousin by the name of Mickey Gonzalez who owns a air conditioner refrigeration business, and they're prepared to have him work. I mean, they have a job ready for him. He graduated from Western Tech, so he is capable of that type of work. Other courts, when we had heard them before, they ordered a PR component, which we would ask for as well. We'd ask for the drug testing. If the court feels an inclination to have electronic monitoring just to make sure that he gets to all of his court appearances, we have no problem with that. If Your Honor could reduce the bond somewhere in the neighborhood of about 15 to 20,000 with the rest PR, he may be able to make that. It's still going to be a hefty bond, regardless, because of the other bonds that he has that have already been reduced. But that's what I have on his behalf, Your Honor.
Your Honor, and I'm sorry, I didn't check the rap sheet, but it looks like he does have history from Nevada. And so he does have pretty much kind of the same types of charges. And I'm just checking, like DWI. I saw a robbery, I think. Where is it? Burglary from 2007. Larceny. Robbery from 2008.
Did he ever do time in Nevada?
Yeah, let me just confirm, Judge. I'm looking at the. Looks like he pled guilty on this felony. Concurrent. Ugh. Yes, he did. Nevada State Prison in 2018 for grand larceny. It says Nevada, yeah, I just can't see the. There was a violation of parole in 2020. I just can't see how much time, Judge. I would have to get the actual.
Yeah, well, that's okay. But he got out, and then he got a parole violation on top of that.
Yeah, there was right then in 2021.
Is there gonna you don't have a rec yet combined on all this, do you?
Not yet, Judge. But it's gonna be TDC.
Yeah, it'll be a pen rec, looks like.
Yeah.
Okay. The one that you're asking me to reduce the bond is the one that's involving.
It's the one in the 34th District Court, the 1264.
Yeah. Okay. I don't know, this history is pretty extensive and committing a lot of alleged offenses here in El Paso. Most bothersome one is, leaving the scene of an accident. Appears more concerned about 2 bags of drugs than he is about the safety of the people that he just hit in the other vehicle. That's not fleeing the scene also is indicative of not, I don't know if he'd want to stay around for court hearings either. I don't know. But he said he did come back here to try to answer some court hearings. No, I'm not inclined to reduce these bonds, so it's denied. But I do get a rec fairly quickly to him so that we can either get the case to trial or whatever, so he at least knows what the state of Texas is thinking on all of these combined cases. This is a lot of cases.
Yes, Judge, I will.
All right, thank you. Okay, well, thank you, Mr. Pettis. Thank you very much, Mr. Carmona. We'll be trying to continue with your case. And let's proceed with the next case, which will be Mr. Morales. You're there, Lenny. Let's talk about Mr. Torres. We've had a bond hearing on him once before, right?
I think so, Judge. The case has been sitting for a while, so we just wanted to see if you might reconsider or consider other terms and conditions of the bond.
What, is this case set for trial?
I want to say,
It should be, because, oh yeah, trial is
Should be.
May 9th of this year. No, it was May 9th of last year. Okay, now when is it set?
I didn't see a setting, Your Honor. I think we need to set it.
Michelle, do you see a trial date pending? Okay, we're gonna have to set that one pretty quickly. It's a 2021 indictment. Oh, we don't have the defendant yet.
that might be helpful, Judge.
How long has he been in jail now?
It's been a while, Judge, since approximately May of 2021.
Let's see if we got the number of days here.
648 days, Judge.
Then we gotta get this case tried within the next 4 months. Okay, this is Mr. Torres, and what the bond is presently, what, about 200,000?
It's 250,000, Judge, yes.
Right, 250.
I mean, the facts are pretty egregious in this case, Your Honor.
And you've got a couple of pen trips, is that right? Two different, this is
Yes.
like a minimum 25-year sentence.
Yes, it is, Your Honor.
It is, Judge, and the reason that we're asking for the court to consider a bond reduction is just the length of time that we've been waiting to go to trial now, Judge, and my client has not been able to raise the kind of funds that are necessary for the bond. So I think at this point, the bond is clearly excessive, Judge. It's oppressive, and I think that there, at least the court could exercise some relief here. My client previously lived with Teresa Torres Garcia, his mother, at 7202 Dale Road here in El Paso, Judge. I've been in contact with her as well, and they're willing to take him back, and he has a solid place to live. He had been working as a plasterer, Judge. He has his GED. He's a lifetime El Pasoan. He has family in town, a brother, 2 sisters. I understand that these accusations are egregious, but they don't involve direct family members, Judge, at least not anybody that my client would have any continued contact with, even if he were out on bond. So at what we're asking for, Judge, is some reduction of the bond pending our trial. There's a number of things that have yet to be resolved. We've been delayed by COVID and things of that nature, but I understand we're getting back on our feet. And
I've already tried two. Yeah, I've already tried 2 jury trials this year. I'm about to try a 3rd.
Yes, sir.
I know.
And
I
I'm
know
right
you're.
across the hall, Judge, with my trial right now. So we're
I know you're
awaiting
trying
a
to
verdict
take-
on that one.
All right. Let's see. Your position, Ms. Espinosa.
Your Honor, as I said, I mean, the facts of this case are just very egregious. He allegedly abused his daughter for about 5 years. Additionally, we have been in contact with our complaining witness. She is still very, very afraid of the defendant. He made some threats, apparently, if he were to be released. And so for their safety, and obviously, because the recommendation is 25 years, and that's the minimum, we think that Mr. Torres would be a flight risk and is a danger to the complaining witnesses.
I'm going to deny motion, but we are going to set this case within 4 months. So, Ms. Nolasco, let's set this case pretty quickly. We need to get it resolved.
Very good,
All right.
Judge.
Thank you.
Now, Judge, the only thing that just to give you a heads up, Judge, the only thing that might be in the mix on my calendar, Judge, is I'm on the team with Facundo Chavez. We're trying the Deputy Peter Herrera case.
Yeah,
And
when
that's
is that
gonna
going
be
to
in
trial?
May, June, Judge. We're in the middle of jury selection right now.
Right, I know, yeah, I know you're in
Yeah.
jury selection now, so,
We have May 8th, Judge, for Mr. Torres.
well, we could, but then he's gonna be in the capital murder trial. I can't then try that until he's done with that case. So you're looking the earliest July or August, right?
Probably, Judge, yeah.
When? July or August?
Probably looking at a August, Judge.
Okay, let's set the trial in August.
Yes, sir.
All right, and in the meantime, Judge, I'll have time to work this up. I'll get with Mr. Torres and we'll get things in order.
All right, very good.
I'm glad that
Thank
we're
you.
finally moving forward, at least, Judge. We need to get going on this thing.
Yeah, we do. Indeed. All right, thank you.
Okay, I'll be out to see you, Luis.
Thank you. Okay, we have the
Thanks,
next,
Judge.
both of those are with the public defender. Which one who wants to go first, Mr. Caballero or Mr. Morales?
Mr. Morales, Judge.
That works well, Judge.
Okay, so that's Alfonso. Is,
That is correct, Judge. Mr. Alfonso has been in custody for about 2 months now. I think he went in right before Christmas.
this is one that it looks like Michelle did the judge's pretrial. Looks like her handwriting, not mine, so it's easier to read. But I did let's see, we revoked a PR something here.
Um,
Okay, so he's been in jail 63 days. And what's the bond set at?
You got one for the burglary hack, Judge, 20,000, and then the PR rebel assault, 125,000.
and Judge, I'm not sure if this is part of your facts, but in the 5495 case, there's actually a neighbor who witnessed the assault.
Okay, we got a 2022 4058. And now there's a 20, what? Another,
2022 5495.
and that's also, that's another assault, family violence.
Yes, and burglary of habitation.
Is that an impeding also, or?
Yes, he pulled her out of the apartment. And then began punching her in the face. He was
These are
choking her.
the same complainant,
Yes, Your Honor.
2 different indictments. They occur, one of them, is it December of 2022 and the other one August of 2021?
Yes, the latest one is December 7th, 2022.
That's what I revoked the PR bond for. Because he was out
Yes.
on a PR bond component for doing the exact same thing.
Yes, Judge, except in this situation, he actually broke into the apartment.
Right, this time he broke in. The other time he,
They weren't together anymore, and he still broke into her apartment to assault her. And the neighbor, one of the neighbors saw. And I think she's the one that called police. I'm not sure.
Now are they married or separated, or they've got some children together? Three.
They are married, and obviously they're physically separated now, but they plan to permanently separate in the future, and they're hoping to co-parent successfully. I believe they have 3 children, and including maybe even a a very new baby, Judge. And there was a period of time, Judge, obviously I know you don't want to get into too many of the facts of the case, to disputing those facts, but in reference to the burglary, I believe he was living there at the time. That would be our contention, if we ever got into anything contested. But I know that they were back and forth, but they do plan to separate permanently at this point, Judge.
And so what kind of bond are you asking for, Mr. Morales?
Judge, he's been in custody over 2 months at this point, and we wouldn't want to lean on the complaining witness for any resources to bond him out. I know she has those 3 boys to care for. I have been in contact with his mother and his brother. They've both been in here into the office this year. I think they might be able to make something very, very reasonable, but we'd be asking for a significant portion on PR if the court decided to do a split bond instead of do a full PR, Judge. I just don't know that they can come up with all that much, Judge. I wouldn't think they'd be able to come up with more than about $500, Judge. I think that would be stretching it.
Well, they
I
couldn't do
didn't-
more than about a $5,000 bond. Cash surety.
I didn't have a recommendation before, Your Honor. But at this time, I'll put in a recommendation of 5 years deferred with BIP. If the defendant is.
Evelyn, I know that we had a non-prosecution affidavit for one of the cases, as far back as 11/22. And I'm looking at it now. I do have it. If you don't have it in your file, I can send it to you.
Well, you may not get one in the second case because they're probably doing it twice, probably didn't, or allegedly doing it twice, probably didn't help.
Judge,
And honest, yeah, and even if we did get a one on the new one, we have a witness, an independent witness.
and-
I'm just not, when I have somebody out on bond for the same thing and it's the same allegation, I'm just not very inclined to lower bonds. I mean, I raised it because I was in fear that, something else would happen. And we have a third case.
And I certainly understand your concern, Judge. I will tell you that not only has the complaining witness signed non-prosecution affidavits in the past, and she's available to sign them in the future. She calls me frequently, Judge, but she does say that they have no intention of getting back together at this time, but that she does not want Mr. Alfonso to continue to be incarcerated, Judge. I certainly get the court's point on that one. I know that in the spring of last year, he was cooperating and had done some BIP style classes along with Beyonce's as well, Judge, and when CPS was involved, and this would have been back in April of 2022. I'd love to see Mr. Alfonso out assisting me in the defense of this case, preparation of the defense. And then if he still has substance abuse problems, whether that be alcohol, something along those lines, Judge, getting him the anger management BIP style counseling that he needs and getting in any substance abuse treatment that he needs, rather than keeping him locked up merely because he can't make the bond. And then at some point in the future, if it ends up being a plea, then he's out anyway. If the state of Texas doesn't want to lock him up and again, I don't want to put words in Ms. Espinosa's mouth, but that recommendation to me makes it sound like they don't want to, they're not trying to send them to TDC, and if they're not trying to send them to TDC, then doesn't the bond, isn't it just punitive at
Well-
that, keep him in jail, Judge, until he.
But that's only if he's agreed to already at that point, take a plea where the conditions are no contact with her. They have to work out a way to have contact with their kids and then start BIP classes immediately. And then obviously if he doesn't complete that, then it is TDC time.
And those are great, Judge. I don't think Mr. Alfonso would have any problems completing those. And then in reference to, they do have 3 children. I know the mother is here and she's local, and I know the brother is here as well. So
Okay, well, what I'm gonna do is, I'm gonna deny it until I can have a further hearing where I can hear from her in person. I want to see what she has to say.
all right, Judge, I'll see about bringing her in, Judge.
All right.
Thank you, Judge.
Thank Okay, thank you. Okay, let's talk about Mr. Morgan last.
Tell me if it's been checked.
All right, what's going on with Mr. Morgan here? We have. I've already done one bond hearing on him.
We had one, Judge, and then he was released, and he was recently, subsequently arrested back in November.
Oh, yeah, you're right. In June of this year, I had a bond hearing and I let him out.
Yes,
And
and he was
now what-
complying. Yeah.
And now we've got another problem.
We
PR violations. He got
yes.
rearrested for more charges.
Yes, Judge, and I think what we're seeing on the docket, a number 2023 0D00111, that case looks like it's dismissed, and they refiled as 2023 0D00355. But I don't have access to that one. I don't think I've been appointed to that one yet either. I tried to check portal on that one, but it says I don't have access. I need to contact the DA's office. It looks like it hasn't been opened in my office either.
Yeah, I don't know.
You haven't been appointed, that's why.
It doesn't, it generally doesn't impress me that when I'm giving somebody a PR bond and they go out and then there's commission of other offenses, that's not a good showing. Not good at all.
Yeah, I'd like to get into the facts, Judge. I just don't have the information to go into further.
Let's see.
Yeah.
I might have some of them. Let's see.
Oh no, with regards to the new case, Judge.
Yeah, the new case.
Yeah.
Is this the 2023 0D0355?
Yes, Judge.
Yes, yeah.
Okay, so what are the facts on the new one?
On that case, like Mr. Caballero said, it looks like it was just re-indicted, but I'm not sure why. I'll have to figure that out. This allegedly occurred on November 9th of 2022. Let me see.
Yes, November 9th, 2022.
Oh, no. Okay.
Because that's
Um,
why I revoked his PR bond on November 21st, when I was informed that he had been rearrested for obstruction, retaliation, POM, evading, and manufactured delivery 4 to 200 grams.
Yes, Judge, it looks like the defendant was placed under arrest for evading arrest, and outstanding traffic tickets on that day. And then when he was taken in and searched pursuant to a secondary search, there was a bulge found in the crotch region and in a large shop, I guess it was in a large shopping bag with within the shopping bag, there were various types of narcotics. And they were listed as 23 individually packed baggies of crack cocaine, one baggie of a large rock substance, also cocaine, 2 large pink baggies containing crystal-like substance, meth, 2 small baggies containing crystal-like substance, 1 baggie containing 17 blue in color pills, fentanyl, and then 2 baggies with a green leafy substance, marijuana. I can give you let me check if we have, it was a total of 33 grams of cocaine, 34 grams of meth, 6.5 grams of fentanyl, and 0.2 ounces of marijuana.
How much cocaine?
33.5 grams.
Well, the packages indicate that it's not just for personal use. This is looking like dealing. Okay, anything you want to add, Mr. Caballero?
Yes, Judge. He can't afford the bond. He's been in custody for 92 days. He does qualify for us to proceed under a 17032 bond hearing. He does have a confirmed diagnosis. Mr. Morgan has been getting mental health treatment in jail. He's also continuing his classes on the tablet in jail, and he's been participating in a program there as well, where it's like they bring a few inmates together and they go through exercises such as anger management or coping skills, and they discuss issues with substance abuse and how to best cope with things like that. In addition to this, Judge, I did reach out to Mario from Casa Vida, and I did talk to him about Mr. Morgan, his history and his current issues. And he says he does qualify for Casa Vida from their point of view, and he would like to have him. However, there's a 45-day waiting period for that program. But if released, and I did speak to Mr. Morgan, Mr. Morgan would like to participate in the residential program of Casa Vida.
Well, I don't, but the other case is almost identical facts, isn't it? I mean, it's again, the bulge and hands and the, fairly substantial amounts of
Oh, I see. And Judge,
fentanyl and-
yes, and I do see why they had to re-indict it is because I guess because of the fentanyl, which is penalty group 1B. And before they only had it listed as penalty group 1. And that's the reason for the re-indictment.
Okay, I guess, and we still need to get reappointed. We need to get appointed, and I think he also needs to be served with that indictment as well.
Yeah, well, no, there's just no way I'm gonna give any bond relief for identical cases back to back. I mean, of dealing, and now if there was any question he was dealing the first time, there's now no question the second time. As far as that evidence, it seems, I mean, of course, it certainly can be contested, and it's not, proof beyond a reasonable doubt or anything, but those facts do not look particularly favorable.
No, Your Honor, he has he allegedly was caught with bearing drugs, but there was no surveillance or they didn't catch anyone trading drugs or obtaining drugs or anything like that. Just by virtue of it being a different kinds of drugs, it's not as dispositive, I would say.
What was his criminal history again? I have to go back and look at that.
He's never been to TDC. I believe he had a one state jail conviction, and that may have been it.
It looks like I was fairly lenient the last time. That the rec is a TDC rec on the first case alone of 10 TDC. You know, but I think I was pretty lenient on the first one. I mean, the bond was still fairly high at 50,000, cash surety 50,000 PR. I guess he made that bond.
No, Judge, he got a PR bond on those.
Oh, okay. Well, yeah, no, no, I can't do a PR bond again. That's just no way. It's not possible under those alleged facts.
Okay, Judge. Evelyn, can you look it over when you have a chance, and then put a recommendation? That way I can speak.
Yeah,
to
he's
Mr.
gonna need a combined rec on both cases together. So
I
we
mean,
can
the
discuss.
recommendation, okay, I will. The recommendation before was 10.
Okay. I'll look, and Mr. Morgan, if I don't get access to the next to the new chart, the new case, I'll have to see you next week, probably Monday or Tuesday, because there's no point in me going on if I don't have the cases to show you the actual facts to discuss. Okay. But if I do get them, I'll go tomorrow to see you.
All right, thank you.
I mean, like, what does this leave me at in this situation? I mean, because like, you know, I mean, the cops, they always harassing me and just running up on me for no apparent reason.
Yeah, I'll talk to you about that, Gregory.
I mean, he's saying something about me catching the same charges over and over. I mean, but I mean, come on, man, they can't just like come at me just because of who I am. Like, if they don't have probable cause to run up on me, like, why do they keep, you know what I'm saying, coming up on me and doing the things they're doing to me, bro? I don't think that's not right.
Okay.
And he'll have a chance to file motions to suppress if he feels that he needs to do that. And we can litigate all those suppression hearings if we're headed in that direction, which is fine.
Yeah, we're gonna discuss that, Mr. Morgan. Right now, we are live and it is being recorded, so I would just advise you not to say anything for right now. Okay?
Okay, thank you very much. Is that all of the bond hearings?
That's it, Your Honor.
Yes, Judge.